Hello viewers, welcome to one more episode with Mrs. Shweta Anand and the team at Kalpavruksha. In the previous episode, we discussed about the legality of mediation and how it bears its authority in law. In today's episode, we are going to discuss the various other methods of ADR like mediation, arbitration as well as conciliation and try to understand what the difference is between all the three as well as which is more effective for you to resolve your problems in a cost-effective and a timely manner. Namaskaram, madam. So, like we discussed previously and what we want to discuss in today's episode, we've been talking about various different types of ADR, different types of alternative method resolution like conciliation, arbitration and all that. Can you please explain to our viewers what is the difference between all these things and how all these things are conducted like arbitration and conciliation?
It's a good question, Mr. Abhay, because normally what happens, there is a confusion in the minds of the clients or the litigants, because there are various methods which has been adopted by various persons in various fields, and judiciary also has given many alternative dispute resolution forums. So like how we discussed about Lok Adalat and then mediation centers, arbitration, conciliation and negotiation. So they're all alternative dispute resolution. Now persons will get confused whom to approach, how to approach, and whether our case will fit into arbitration or in mediation or in conciliation. So it's a truly good question, because I would like to highlight the effects of mediation, effects of arbitration, because these two are the major dispute resolution forums which are conducted by both judiciary and also private mediation centers. So now, for example, arbitration. Let us take a look at arbitration. See, arbitration is an enactment in itself. Mediation is not an enactment. The bill has not yet come out. Now the central government has taken a step towards making the mediation as a statute itself. Whereas the Arbitration Act is an act and it is amenable to jurisdiction of the courts. So now when we speak about arbitration, arbitration is an arbitrator who resolves your disputes with the consent of the parties when an issue has been arisen. So here you will give consent and you will agree on single arbitrator or a dual arbitrator, which will be referred to the again umpire arbitrator. So or one solo arbitrator also. So there is a written documents. Normally what happens in commercial transactions, what we see. For example, state to state wise transactions, and then international transaction, commercial transactions, and then many agreements which involves crores of rupees and also which involves much technicalities. So under such circumstances, not just a mediator is sufficient, because of the reason that, for example, arbitration is also a method which works under the provisions of the Code of Civil Procedure. And within the judiciary itself, it is a different part in itself. And not only that, it has to act within the framework of constitution and law. So, arbitrator, when he is appointed under a written agreement by the parties, first and foremost step is both should agree and then select an arbitrator. And if selected priorly in the agreement itself, the matter will be referred to the arbitrator. There in the first phase itself, you have to pay a lump sum amount to the arbitrator, like how you pay the court fees. And then second thing is the documents. The judgment is based on the voluminous documents or maybe some few documents, and then taking evidence if necessary. And then it is something like procedure of the court which is followed in a short format. Here the advantage of judiciary and arbitrator is you select a person to be your judge. There in the judiciary you cannot select. You have to take the assistance of a person, that is advocate, and argue before the court. Here before the arbitrator, either you can go on your own or with the help of the advocate. So you can partly in person, party in person, maybe even in courts also. But here you have full liberty. And not only that, too much technicalities like court is not followed in this. Strict rules of evidence, strict rules of practice are not adopted, even though it is working under the framework of judiciary. So, now what happens? When you go before an arbitrator, the arbitration proceedings will start. It will take its own course because it may end up with 2-3 sittings or 4-5 sittings. You are submitting yourself to a judge, and judge will pass an order based on your documents, based on your evidence, and based on the question of law. So whether it is binding or not is also an issue, because a judge will give a judgment where one party loses and one party wins. Then second thing is, only there are no scope for challenging the arbitral award, but there are few exceptions where you can challenge the award before the civil court.
Continuity of litigation happens in an arbitration.
It happens. But same way, when you compare with the mediation, mediator is also appointed by the consent of the parties. But here, there are no rules of practice which compels the mediator to adopt and give a judgment, because mediator is a facilitator. He is a bridge between the two parties. He is not acting as an arbitrator or as a judge. He is an impartial, independent person. Then you can depose confidence in him, and then you can speak to him in confidence, which shall not be made public unless the party accepts it to make public. Whereas in arbitration and court proceedings are public. No evidence is required here, because the mediator will take his own course and use his techniques to feel that whether you are wrong or the other party is wrong. You will analyze yourself, whether you are wrong or you are right. So when you analyze yourself, you will feel that I am ready to forego some part of my share. So when you are ready to forego, the other side will also come forward and say, I am also ready to forego. So it is a win-win situation. And there is no allegation against each other. There is no animosity. And there is no litigation, because you can't call it a litigation. You call it as a settlement.
Not a discussion. Correct.
So, because you are negotiating your settlement terms. See, mediation is mainly based on negotiation. Negotiation is by whom? By the parties themselves. They are the masters. They conduct the proceedings. And they say, I want this or I don't want this. In the event of the worst problem, if mediation fails, you can always go before the court. It is not an end in itself. If both the parties accepts and says, yes, we are happy with whatever I got, I would like to reduce it in writing and make it as a settlement. Then that deed, either family settlement deed or any other partnership deed or any deed, can be reduced in writing by both the parties, get it registered before the sub-registrar, which becomes a document recognized under the law. So the time consumption, the money involved, and the parties' participation in mediation is more. So what do you feel about these two? Because when a common man understands, for commercial transaction, normally we say it is better because too many question of law is involved.
Correct. So I think you should give the viewers would like to know which is better at what circumstance, whether it is mediation or should I go for arbitration.
Correct. So now you have understood the difference.
Correct.
See, arbitration is very good for commercial transactions, or even small transactions, like in the partnership form there is a mistake, there is a commitment, and then even loan transactions, finance transactions. See, all civil disputes and monetary involvement wherever is there can be referred to mediator. Even arbitration proceedings also can be referred to mediator if question of law you will not ask the mediator to answer. because you want a dispute resolution, not a judgment.
So, if I am not wrong, if there is no question of law that is involved, then any problem can be settled by way of mediation.
So it's wrong. Question of law is also involved. But parties say that I don't want question of law to be brought. See, for example, I'll say rental agreement. If a rental agreement is there and question of law is involved in that, because 11 months agreement is there, if it is not renewed, then he has to vacate the possession. Correct. So either he has to go for eviction petition, or he has to convince the other party by saying, I need it for my own use, I will pay you some more money instead of you paying me. So they take entire advance. Please vacate. Correct. Here also eviction, law of eviction is involved.
Correct.
Question of law is involved.
Correct.
People know it very well. And when he goes before the court also, the court will say deposit the rent to the, and then it will take its own time, around 5 to 6 years, 7 years, because appeal provision is there.
We have seen rental disputes go for 10-15 years.
Correct.
Person dies before enjoying the property.
Enjoying the property. Why it happens? Because at that initial time, neither the owner gives some time for vacating, nor the tenant will accept that I will vacate within 100. So it takes its own time. So for 8 years, 10 years, it is true that he will get the rent, but what rent he will get? The earlier rent, isn't it? And even ultimately the court will give them the time to vacate the place. So instead of that, when you select a mediator, when you go before the mediator for settlement of the issues, then the mediator will take her own course, and then she will use or he will use own techniques and see that what is that both parties are interested. If both parties are interested, if the owner is interested to give some money and get it vacated, or give some time, for example 1 year, 2 years, and he will vacate, enter into a settlement terms. So that settlement terms are binding on both the parties. Then he cannot go for eviction. So even question of law is involved, but parties give away their right. Parties needs a settlement. When parties need a settlement, with that psychology, they come before the mediator. It's very easy and very convenient for everyone. So no litigation, nothing, no heart burnings, no animosity, no allegations.
So to conclude, based on the discussions that we've had over the several episodes and today's episode, as well as your opinion, it is right to say that where a question of law is required to be answered, then the parties should move towards arbitration.
Or judiciary.
Or judiciary, yes. But whereas when it is a civil dispute, where it is a family dispute, where it is about money, taking and giving of money, I think in your opinion, I think even in our viewers' opinion, mediation looks to be the most appropriate, time-saving as well as cost-effective method of resolving these disputes.
Not only cost-effective, it also retains your relationship. See, for example, husband and wife, sister and brother, they come before the court for property matters. So there the question of law, even though involved, but the sentiments are more involved. So we want to protect this. We want to bring a new era saying that always going to the court will not bring you any good luck. Win-win situation should be there between brother and sister.
Yes.
So I always focus on mediation because of these reasons which I have explained it to you even in earlier episodes. Retain your relationship. Come back to the mediator. See that how it could be resolved. And see everybody will have the same opinion that we have won the matter. So nobody should be a loser, nobody should be a winner. Both are winners.
Thank you. Thank you, viewers. So in today's episode, looks like we've learned a lot about ADR, the different types and methodologies used for common people to resolve their issues before going to court or even after going to court. Yes, after learning brief about all these topics, please stay tuned for the next episodes where specialists will be called experts in each field to give you detailed analysis of subject-wise topics so that you can understand how to effectively use law to support you in resolving your conflicts and issues. Namaskar. Thank you.